Good afternoon. I'm Jeffrey Lang, L-A-N-G. I'm the acting United States Attorney for the Central District of Illinois. I'm just going to have a very brief comment. I'll repeat basically what I said back when Al-Marri pled guilty. Thanks to the efforts, the expertise, the cooperative law enforcement efforts in this country following September 11th, Ali Al-Marri was taken into custody before he could do what he came here to do, and that is to facilitate acts of terrorism within the United States on behalf of Al-Qaeda. You heard the findings of the judge today, the court, that he came here after being in training camps, being a courier of electronics for Al-Qaeda, after having met with the top leadership of Al-Qaeda, and came here with instructions to arrive on no later than September 10th, 2001, and to be a sleeper agent. The court concluded that he was a sleeper agent. And the evidence that was presented during the sentencing hearing certainly established that. Now, the various agencies who have worked on this case, the Joint Terrorism Task Force and the other agencies, have been working diligently on this case since Al-Marri was arrested in December of 2001. The prosecutors here, other prosecutors elsewhere, have been working diligently to get to this point where Al-Marri admitted what he was, and we had the sentencing hearing today. And one of the findings that the judge made is that Mr. Al-Marri certainly intended to facilitate acts of terrorism here in the United States, and that he continues to be a risk of terrorism and harm to the United States, as the court said, either here in the United States or elsewhere. At the end of the day, the judge sentenced the defendant to 100 months, and so now this ends this chapter of the Al-Marri case.
Are you disappointed with the 100 months?
I'm not going to say disappointed. What we're going to say is that you heard the government ask for 180 months, and the court sentenced the defendant to 100 months, and the court gave its reasons for doing that.
Can you explain the 3 years of supervised, it sounded like
Sure.
probation, but
Under sure, this is basic and is easy. The law requires that if a defendant is sent to federal prison under the Sentencing Reform Act, a judge has to also sentence a defendant to supervised release, and that's a probation will monitor. It's sort of like probation, but it's called supervised release. The defendant is released and then supervised. During that time period, the defendant has to comply with whatever terms are set by the court.
so he's required to stay in this country?
No, that's he's just required to be on supervised release, and you'll probably want to look at the judgment order, which may have some special conditions, such as I believe in the plea agreement it required him to agree to deportation following his service of his sentence.
But you avoided the word disappointed, but anything less than a 180-month sentence was clearly not what the government had hoped for in this case.
Again, we take positions in this case in all of our cases. When we go to a sentence hearing, we have a position that we advocate, and obviously it's up to the court to make a decision after hearing all the information, the evidence. We asked for a sentence of 180 months, and the court decided 100 months was appropriate in its view.
What about the 9 months for harsh treatment that he got his credit?
Again, the court heard the evidence and made that decision.
So what's your reaction to him reading that statement he wrote in court and crying through it? And were you concerned at that point that the judge was going to lean in his favor because of all the emotion?
If you want to answer that, be my guest.
I think most defendants express a lot of sadness when they're discussing their family members, and I think it's obviously, I'm sure it was genuine that he had not seen his family members, and whatever incarceration he was looking at, he would not see his family members for that time as well. I think that it's important to remember that the judge considers this a very serious offense, and the judge's words based on listening to the defendant's statement was that he did not believe that he truly rejected or was sorry for what he did when he came here and that he would do it again.
The defendant allocuting, of course, is a standard part of any sentencing hearing. Right. Anything else? Any person who comes here and either facilitates an act of terrorism or directly engages in terrorism is going to face a long prison sentence when they're convicted.
Would you agree that there's a lot of unanswered questions still in this case?
In terms of what?
What he was here to do, specifically what he would have been doing had he not been arrested in December.
Well, let me just comment on that. If the agencies hadn't been as effective, the FBI and other agencies as effective, and you heard today there were several different tips to the police and to the FBI concerning Mr. Al-Marri's unusual conduct. If there hadn't been that, then perhaps his scheme would have played out further. But of course, the priority of the Justice Department, the FBI, and the U.S. Attorney's offices after September 11th was to prevent any acts of terrorism from occurring. So on December 12, 2001, Mr. Al-Marri was taken into custody before he could accomplish what he came here to do.
Even the judge admitted in his statements, finding cyanide and water sources on that laptop computer in and of itself didn't necessarily spell out exactly what he was meant to do, but that was clearly a sign that he had nefarious things in mind.
And I think you heard the judge say that was a reasonable conclusion or a reasonable inference by him after reviewing all the evidence in the case.
What does this case say to other people, perhaps detainees at Guantanamo who are still waiting for due process? What does this case say to them?
Well, I'm not going to speculate as to that. What we do know is that in January, the President ordered a review of Mr. Al-Marri's case and other cases of Guantanamo detainees. As a result of the review of this particular case, we charged Mr. Al-Marri, and we're preparing to go to trial when he decided to enter a guilty plea. And now here we are today at sentencing.
So where exactly will Mr. Al-Marri be headed after he serves his time? Do you all know?
That's up to the Bureau of Immigration Customs Enforcement, I would guess. The Department of Justice, Department of Homeland Security will review his immigration status or lack thereof and send him to wherever he is supposed to go under the law.